Hi everyone, this is Erik Stone with U.S. law member firm Jones, Skelton & Hockley out in Phoenix, Arizona. We're an insurance defense firm. We represent insureds, self-insureds, governmental entities, corporations, and other professionals. My area of practice focuses on commercial litigation with an emphasis on employment disputes, intellectual property litigation, and other general business disputes. Today I'd like to talk to you about an emerging trend in intellectual property litigation, specifically misappropriation of likeness claims. Here in Arizona, we currently have about 2 to 3 dozen such claims that have been filed by one group of about 50 models that is headlined by Miss Carmen Electra. I represent or defend about half of those cases here in Arizona. Miss Electra and her colleagues have brought these claims against bars, restaurants, and nightclubs for the use of their image in online advertising. Now, obviously, some of the things I will discuss today will have some carryover for any company that has any sort of online advertising campaign or presence. So I want to talk to you about 3 things. 1, the claims and damages that are sought. 2, potential defenses, and 3, some ways or ideas that we have for you so that these claims are not filed in the first place. These claims are brought by a law firm, the Casas law firm out of San Diego. That firm uses internet software to identify usage and what's a usage of images online, and once identified, they file a lawsuit alleging 3 causes of action. 1, violation of the Lanham Act for false endorsement. 2, violation of the Lanham Act for false advertising. And 3, a state law claim for misappropriation of likeness. On average, these plaintiffs allege or seek approximately $50,000 to $100,000 in damages depending on the model. Potential defenses to these claims are as follows. For the false endorsement claim, we argue that some of the models have not established the requisite notoriety or celebrity status required under the Lanham Act. Now, obviously, Miss Electra could establish such celebrity status, but the vast majority of these models are simply beautiful women that have at one point in their life appeared in a clothing catalog or a bathing suit catalog or the like. They just simply don't have the notoriety or celebrity status needed to prove their claim. Under the Lanham Act violation for false advertising, we have been successful here in arguing that the plaintiffs and defendants are not direct competitors, which is a requirement under the Lanham Act. So those claims have been dismissed because the plaintiffs are not direct competitors with the defendants here. Lastly, we've been successful in arguing that the misappropriation of likeness claims should be dismissed because Arizona has not yet recognized a claim for misappropriation of likeness. The reason is because the state legislature here has only recognized such a claim by statute for military personnel only. The state superior courts here have agreed with that argument, but the federal courts yet have not. Lastly, ultimately, if you don't want to have these claims filed against you in the first place, we recommend working between your legal department and your marketing department to ensure that any online advertising content is either owned by your company or properly licensed. Now, before I go, I was asked to give my recommendation for a lesser known vacation spot here in Arizona. Most people think of Arizona and they think the desert, but we have a town in northern Arizona, about a 2-hour drive north of Phoenix, that sits among the pines called Flagstaff, Arizona. Some great hiking spots, great places to eat, so I highly recommend next time you're in Arizona to try and make a trip up to Flagstaff. Again, this is Erik Stone with Jones, Skelton & Hockley. If you'd like to have any discussions further on this matter, you can email me at estone@jshfirm.com. Thank you.